privately owned farmland in the proposed next era footprint. We also recently learned we are in the path of a somewhat carbon pipeline, and 7 years ago I signed a wind energy lease in Cerro Gordo County. That project was never completed due to federal tax credits expiring. But because of my experience with all of these projects, my experience as a tax preparer, and seeing the amounts landowners actually get paid, and hearing the stories of I didn't know, or that's not what they told us, I talked to Tammy Hurd, and we decided we needed to start working together to share information, to hear from others who have experience with wind energy so that we can all make informed decisions. While my family will not be signing a wind lease, we respect the decisions of those who want to. My hope is that we can value the rights of property owners while considering our neighbors. Please keep an open mind here tonight and respect the opinions of others. Our main speakers tonight from Worth County are Jeff Moorball and Julie Combs. We will also hear from some Worth and Cerro Gordo County landowners as well. Our first speaker is Jeff Moorball. Jeff is a current Worth County supervisor. Nope.
Zoning Commission.
He's on the Zoning Commission. Is very familiar with and successful in navigating wind turbine discussions, serving as the chair of the Worth County Planning and Zoning Commission. Jeff is also recently retired as Managing Director of Kingland Systems in Clear Lake and is a United States Marine Corps veteran. Julie Combs is a former Worth County resident living in Cerro Gordo County. She is a fifth-generation Iowa farm girl and quickly became a leader in the wind turbine discussions in Worth County, being featured in discussions with the Sierra Club and featured in Forbes magazine. Please help us welcome them, and I will let Jeff take over.
Thank you. Thank you, everybody. Honored to be here to speak with you tonight. Just as a matter of introduction, Candace already went through who I am. I've been retired since 2018. I've been involved on the Zoning Commission in Worth County since 2008. I've held the position of Zoning Administrator in 2020 and 2021 after the untimely death of our Zoning Administrator at the time. And since 2021, I've also been the Chair of our Zoning Commission. During our efforts with wind ordinance over the last couple of years, I led that effort to do research across all the variety of counties all over Iowa, what existing ordinances were in place, and then the expansion of countywide zoning. So tonight, I want to make sure that you understand we're going to talk about some legal things tonight, but I want to make sure everybody understands up front, I am not an attorney. I do have a lot of experience in reading contracts. Over 18 years with Kingland, I was responsible for a variety of client and vendor contracts. So I have some familiarity with the legal language, and I know that words mean things. I'm also not anti-wind. I'm not pro-wind. I am pro-rights. I spent a very large majority of my life protecting individual rights. And I feel very strongly about those, and I don't think that anybody should bulldoze over anyone else. In fact, we'll talk later tonight about the variety of stakeholders involved in these kinds of things and the need for discussions amongst all of those stakeholders. So what I plan to talk about tonight is we'll go through our recent activities and experiences in Worth County with regard to commercial wind. I'll go through a timeline of those events, and bear with me on the timeline. There's a lot of stuff there, but I think it's really important so that you understand each of those items in context. We'll also talk a little bit about the Worth County ordinance related to commercial wind. I won't dive into the ordinance. There's a lot of details there. It runs to 30 some odd pages. If you want to read it, it's available on our website. And then finally, I'll close with some comments on issues related to wind easement agreements. And I'll preface those conversations, once again, with the acknowledgement I'm not an attorney. You need to seek an attorney with regard to those wind easements. And I also don't know what the language is of the wind easements that are being proposed to you folks today. I can only speak to the language in the wind easements that I read in Worth County when things were happening over in our Deer Creek area. So that said, we're going to start with the timeline, kind of the abbreviated timeline in Worth County. In the 2017-2018 time period, Invenergy had created a project called Freeborn Wind. That Freeborn Wind was a project that was supposed to happen in Freeborn County across the border in Minnesota, across the border from Worth County. That didn't happen. For whatever reason, they moved out of Freeborn County into Worth County, into the Deer Creek Township, which at the time was unzoned. Now keep in mind, at this time period, Worth County had 12 townships. 3 of those townships that run along the I-35 corridor fell under the Worth County zoning ordinance. The rest of the 9 townships did not. They were exempted from that zoning ordinance, and so it was free game for anybody to do anything. So Invenergy came in, they started developing, actually they sold the development to another company who started developing the wind turbines there in Deer Creek, and then Invenergy turned around and started buying wind easement rights in the west and central part of the county. Fast forward to 2020. Most of the turbines in the Freeborn Wind project in the Deer Creek Township of Worth County had been installed. Now, those were installed in some cases as close as 800 feet to homes, even though Invenergy had told the supervisors prior to that the turbines would be installed no closer than 1,800 feet. But those were all verbal agreements. Nothing was in writing. And when the supervisors asked about why turbines were going in so close to the homes when they were told they would be farther away, Invenergy's response was, we've sold that project to another developer. We don't have any say in that. You've got to talk to that other developer. The other developer, of course, said, that's not our call. We're putting them in where we think they need to go in. As a result of that, in March of 21, actually January through March of 21, there were a group of citizens that got together, I think in 2 or 3 different petitions. Julie was involved with these things, along with a lady named Sue Loken, where they had hundreds and hundreds of signatures on petitions that were presented to the Worth County supervisors saying, you've got to do something about this. They're walking all over us out there in Deer Creek. They're getting ready to put in new plans for new turbines in the west and central part of the county. There's no rules that these people have to live by. You've got to start a moratorium or implement a moratorium to put a pause on this activity until you can figure out what rules need to be talk to that other developer. The other developer, of course, said, that's not our call. We're putting them in where we think they need to go in. As a result of that, in March of 21, actually January through March of 21, there were a group of citizens that got together, I think in 2 or 3 different petitions. Julie was involved with these things, along with a lady named Sue Loken, where they had hundreds and hundreds of signatures on petitions that were presented to the Worth County supervisors saying, you've got to do something about this. They're walking all over us out there in Deer Creek. They're getting ready to put in new plans for new turbines in the west and central part of the county. There's no rules that these people have to live by. You've got to start a moratorium or implement a moratorium to put a pause on this activity until you can figure out what rules need to be in place for these folks to abide by. When that happened, that was in March, that conversation of a moratorium started. Before the supervisors even voted on a moratorium, Invenergy attorney sent them a letter, said, you should not initiate a moratorium. You need to stop this talk about an ordinance. Anything that you do, we're going to be exempt from because we've already started thinking about our project. We have vested rights, and your ordinance is not going to apply to us. And if you pass it, we're going to take you to court. The moratorium was adopted, and the zoning commission was told, begin looking at what rules Worth County needed with regard to commercial wind development in the county. As soon as we started doing that, Invenergy turned around, again, on top of their letter saying, don't pass an ordinance, don't pass a moratorium, They put together what they referred to as a development agreement and asked the supervisors to sign that development agreement. The development agreement was predominantly, they took an agreement that had been in place before that talked about roads and tile lines and things of that nature, and added to that some language with regard to turbine development. And they promised that they would stay 1,500 feet away from homes, they would limit sound to 60 decibels, and they would cause no more than 30 minutes of shadow flicker a day on anybody's homes. That was their term, and they asked the supervisors to sign that. And oh, by the way, another term in that agreement included a clause that exempted Invenergy from any zoning or wind ordinance regulations put into place in the county over the course of the next 30 years. They were doing that while the zoning commission was working on interviewing a variety of stakeholders, doing our research in ordinances across the state of Iowa, doing research in scientific peer-reviewed journals, and looking at state and federal regulations and agency guidance. In June, we provided our recommended ordinance to the supervisors. Note along the bottom there, Invenergy works on supervisors for a separate agreement. They kept that up the whole way. Even though during June, when the zoning commission finally had a draft wind ordinance that we had put out to folks for public comment, we also gave an advance copy to Invenergy and said, here's an advance copy of the ordinance that we're considering. We're going to be asking for public comment on this. Would you please review this ordinance and give us feedback? Their project manager said, absolutely, we'll look at it, we'll give you the feedback. Unfortunately, somebody higher than him said, nope, you're not going to say a word to them about that ordinance, no feedback on the ordinance whatsoever. We're claiming vested rights, we're just going to take it to court. Even though we provided our ordinance recommendation to the supervisors in June, the supervisors didn't do anything with it because Invenergy was still putting pressure on them, trying to get them to sign off on this separate agreement. That finally came to its first head in October of 21, when one of the supervisors said, look, we've been going back and forth with Invenergy on this agreement. We've got the Invenergy project manager here in the room today. We've got their attorney here in the room today. I think we should vote on that agreement. That motion failed for lack of second. It was after that, in November of 21, that the supervisors finally opened up the recommendation, the recommended ordinance that was provided in June, and gave comments back in November and said, we want to make these kinds of changes, which they did. It's their ordinance. They could change whatever they want. So they made those changes. And then a couple of months later, before they acted on that ordinance, after they made changes, they asked the zoning commission to take a look at countywide zoning. Keep in mind, only 3 of the townships were zoned, and the thought was it doesn't make sense if we only have 3 zoned townships, but we're going to try to have a countywide wind ordinance. So the zoning commission took up that question, once again, did a lot of research, did a lot of interviews, public hearings. Ultimately, the zoning commission voted unanimously to apply the zoning ordinance consistently to all of the townships in the county. And then, of course, we had to actually zone those areas of the county as well, predominantly agriculture. And we just used whatever the land use of the land was at the time, determined what that zoning was. So it didn't really change anything for anybody. Then in May, on May 9th of 2022, the supervisors finally do take up a vote on the agreement that Invenergy has been pestering them about since the prior May. So over the course of the year, Invenergy's been going back and forth with them. They finally voted on that. That vote failed with a vote of 2-3. A week after that, on May 13th, before the county has voted on its wind ordinance, before the county supervisors have actually adopted countywide zoning, as soon as the supervisors said, we're not going to sign your agreement, Invenergy filed their petition with the district court claiming vested rights saying that they should be able to do whatever they want in the county according to their plans because they've been thinking about this for a long time and they'd spent a lot of money buying up wind easements from a lot of landowners. The very next week, actually a week and a half later, the supervisors did vote to extend countywide zoning, and that was followed in early June with a vote that finally approved the wind ordinance that was drafted the June prior and that the supervisors had made changes to in November. At that point, the moratorium that they had adopted in April was lifted. As we stand here today, the court hearing for the Invenergy claim of vested rights is scheduled for October 25th, District Court at the Worth County Courthouse. So that's the timeline that Worth County has gone through. There's been a lot of stuff that's happened. Some of the stuff has taken a fair amount of time. Some of it clicked by fairly quickly. Before I go on to another topic, are there questions on the timelines or things that I covered or maybe didn't cover?
Not necessarily a timeline, but could you elaborate on what was changed by the supervisors versus what was recommended by the zoning commission?
Sure. So the question was, what was changed by the supervisors as opposed to what was recommended by the zoning commission? So there were a few things, and I don't recall all of them off the top of my head, but there were some key things. The recommendation of the zoning commission, and it was a unanimous recommendation, was that any setback, anything that applied to sound limits, anything that applied to shadow limits, any of those kinds of limitations applied to one's property. So those rights began at the property line, not at the edge of your house. That was one of the things that the supervisors changed. One of the other things that they changed the distance of the safety setback in a couple of instances. And then they also changed a clause that we had that said, if you have an existing turbine and you perform maintenance on that turbine or you need to replace the nacelle because you've had a fire or what have you, if you replace it exactly like it was, that's just considered maintenance and no permits are necessary. That's just operational maintenance. But if you're going to make it larger, a bigger footprint, bigger turbine blades, larger nacelle, whatever the case may be, if it's different, then that's a different turbine and it has to go through a permitting process. The supervisors said, no, we need to give them a range of percentage of growth. So if it changes, I'd have to look at the ordinance, either 10 or 15%. So if it changes in size by N%, or less than N%, and I think it's 10, it might be 15%. If it changes less than that, then that's operational maintenance, no permit required. If it changes more than that, then it's a new turbine and a permit is required. And there are some other things in there, I don't recall off the top of my head, but I could find out and let you know. Other questions on this? Okay, next I'm going to talk about the next couple of slides that are talking about vested rights and this standard practice, it seems, that these Invenergy companies, these energy companies, not just Invenergy, but some of the others as well, that have this legal threat that they apply all the time. It seems to be a common tactic that as soon as the supervisors or anybody in the county says, wait a minute, our ordinance is 20 years old and it runs to a half a page. We need to update that. As soon as these energy companies, not all of them, but some of them, as soon as they hear that, they're sending letters to the supervisors, as they did in Worth County, and say, no, we've been thinking about this project for a while. We've been buying up land rights for a while. We've got vested rights. We're going to take you to court. And then the rumors start that the energy company is going to sue the county, and the county is going to have to pay back all these millions of dollars that that the energy company spent in buying these land rights, and frankly, it's all just crap. Now, vested rights is a legal doctrine. It is a real thing, and it's related to zoning issues. It's legally, it's used to protect people that have a permit from changes to the rules after that permit has been issued. So, as an example, if I get a building permit that says, I'm going to put up this building on my lot, and it's going to have these particular setbacks, and it's going to be this tall, and I submit that application, and it's in accordance with the rules, and I get a permit, and the next week, those rules change, that would now negatively impact my building. Maybe the setbacks changed or the height restrictions changed. Well, this vested rights legal doctrine says, no, Jeff was issued this permit under these rules. Even though the rules have changed, he's got a vested right to continue that project. Now, there's a lot of what ifs involved in there. And the reality is that if it goes to court, the court goes through a fact-finding trial. And they consider a variety of tests before they say, yes, you have vested rights, or no, you don't. And we'll talk about some of those in a moment. So in this case, when the energy company claims vested rights, it's not automatically granted. They're not suing the county. They're merely petitioning the court to grant them an exemption from certain rules that they say should not be applied to their project. And for most counties, if that happens, the insurance that the counties carry pick up the tab to hire the attorneys to represent the county in that court case. Now, there's another way that vested rights are addressed, and that's typically built into our zoning ordinances today. It's probably in your zoning ordinance. It's called non-conforming activities clauses. And non-conforming activities clauses means if you have something in place and it's okay today, but tomorrow the rules change and so now it's no longer okay, they don't make you tear it down. You can continue that in operation until the cows come home. You just can't change it unless you change it in conformance with the new rules. So you're grandfathered in. And in a nutshell, that's kind of the whole concept between vested rights, is that grandfathering in. And I also want to make note that the courts are not going to fine the counties for implementing these ordinances. That doesn't happen. In fact, you'll see here in some of the Iowa Supreme Court rulings, the first two, I'm going to show you how the Iowa State Supreme Court believes and expects that these rules are going to change. Zoning ordinances are expected to change. The Iowa State Supreme Court has said zoning is dynamic and changing, with any existing restrictions being always subject to reasonable revisions in light of changing community conditions and needs as they appear. Does anybody doubt that the size and the technology of wind turbines have changed in the last 20 years? Does anybody doubt that our state of knowledge and science around impacts from wind turbines have changed in the last 20 years? So it stands to reason our ordinances should change to keep pace as well. Supreme Court has also said property owners in the area affected by a zoning ordinance, as well as adjacent landowners, and I would say persons with wind easement rights, have no vested right to the continuation of the current zoning. Harken back to comment number 1. They expect changes. Now, on the next two, with regard to the ordinances themselves, the language of the ordinances, the Iowa State Supreme Court has said a zoning ordinance, including any amendments to it, carries a strong presumption of validity. And that's because the courts have said the challenger must show, if they're going to challenge the ordinance and say the ordinance should not apply, or the ordinance is bogus, or the ordinance is onerous, or whatever the case may be, the Supreme Court has said the challenger must show that the ordinance is unreasonable, arbitrary, capricious, or discriminatory with no reasonable relationship to the promotion of public health, safety, or welfare. Next, what the Supreme Court has said about moratoriums. Some people claim that, moratorium is you can't do that. You can't just, the county supervisors just can't say, nope, we're going to take a pause on that stuff. We're not going to approve any permits for some period of time. Supreme Court has said the moratorium aids a governing body in performing the legislative task of municipal planning. They aid in bridging the gap between planning and its implementation into legal measures. So looking at the problem, looking at what kind of solutions we need, and implementing that solution takes time. And a moratorium is a perfectly valid tool that governments have to use for that period. They say they may be used to preserve the status quo while study of the area and its needs completed, thus serving a significant public purpose. They've also said, with regard to moratoriums and changing of rules, that with regard to work on completion of a project that has been previously permitted, vested rights to continue development would not necessarily be true. So in my example, I've got a permit. I applied for a permit yesterday to build this house or build this building. I got my permit, and next week they changed the rules. And I knew that they were working on those rules. I have attended those public meetings for the last 3 months because this stuff takes time. Supreme Court has said if the permittee had actual or constructive knowledge of the pendency of the zoning amendment at the time of the issuance of the permit and of the expenditures and work done under the authority of the permit, I still might not have vested rights. So it's not a given. Just because I say I've got vested rights doesn't mean that I do. Once again, the court will decide. They'll look at a variety of things to determine that. My point in going through these things, these Supreme Court statements and the conversation about vested rights, is because Joe Public out here and about in rural North Iowa, we hear these things and we hear the energy company's going to sue our county. They're claiming vested rights. It's, oh crap, I guess we better give up. No, you have rights as well. We have rights. Now, vested rights are a real thing. And if they've got permits, if they've gone through that permitting process, I agree handily. If you've got a permit issued under old rules, the new rules may not apply to you. But if you've not got a permit yet, the question remains, do you have vested rights? Any questions on those things? Yes.
Going back up to the challenger.
Yes.
So the burden of proof is on them to show that it's unreasonable, or
If they're going to challenge an ordinance and say this clause of the ordinance or the ordinance at large is a bogus ordinance or a bogus clause, they have the burden to prove that it's unreasonable, arbitrary, capricious, or discriminatory. Because the Supreme Court has said the zoning ordinance, including any amendments to it, carries a strong presumption of validity. And that's because the supervisors, in their duties, as dictated by the legislature under Iowa State Code, are responsible for developing ordinances for a variety of kinds of things. And we're going to talk about that in a minute. And if they execute their job the way they're supposed to, and they implement reasonable ordinances, that's what they're supposed to do. So for somebody to challenge it, the Supreme Court says, you gotta get over that burden.
well, I'm looking at the no reasonable relationship to the promotion of public health, safety, and could you explain that? Does that go along with the previous wording, or?
Well, the reason, so what she's asking about is saying that, the ordinance has to be shown to be unreasonable, et cetera, with no reasonable relationship to the promotion of public health, safety, or welfare. That's a key phrase, relationship to the promotion of public health, safety, and welfare. That's a key phrase because in Iowa statute, Iowa law,